It was that Benghazi case. We asked for documents about the talking points because we had already uncovered that the Clinton White House or the Obama White House had come up with the fraudulent talking points about Benghazi, but there were no Clinton emails. So we asked again, where are the Clinton emails? And finally, it's exposed, thanks to the pressure from our litigation, that there were all these emails on her Clinton her private server, unsecured, that the State Department knew she was doing, but not one FOIA was adequately responded to, not one congressional subpoena. And we were lied to, the courts were lied to, but we broke it open. And that's what we were in court this morning about, because when you thwart FOIA, when you thwart the law, when you mislead courts, the courts don't like it. And typically under the Freedom of Information Act, the litigation is straightforward. You have questions about documents, you sue, the government comes back and say, we'll give you the documents by this date. We complain it takes too long. Sometimes the courts agree with us, sometimes they don't. We get the documents, some documents are withheld. We fight about that a little bit, but typically it's a paper battle. There are court hearings where we have to appear, our lawyers do, and argue our case. But it's not that common for government officials to have to come in and testify. And that's what's at issue here. We've already had testimony in one of our cases where Cheryl Mills testified. Hillary Clinton was put under oath, at least through written interrogatories. We couldn't ask her the questions in person. We had to propound the questions, send her questions that were written, and she responded under oath. And we're still fighting with her about whether she's going to answer some more questions, because she refused to answer some of them. But separately, in this Benghazi case I told you about that broke open the Clinton email scandal, Judge Royce Lamberth is still considering our requests to have Hillary Clinton come in under oath and answer questions directly. To that end, he called for a hearing this morning. And the hearing, and I'll tell you what he wrote as he called for the hearing. Hold on a second. I got some papers here. 2.5 years ago, the court granted plaintiff's request for limited discovery, mindful of parallel proceeding before Judge Sullivan. This is the case I'm talking about where we received testimony from Cheryl Mills and Yuma Abedin and the written material from Hillary Clinton. And the ongoing inquiries by the State Department's Inspector General, the Federal Bureau of Investigation, and the House Select Committee on Benghazi. Since those proceedings had concluded, it is time to set a plan for further proceedings in this case. So we've been waiting for 2 years to hear from Judge Lamberth as to our request to depose Hillary Clinton. So essentially, we want to know about the bad faith in searching for the documents about these talking points, Hillary Clinton's emails, why we weren't told outright about the emails. And this is what happened. We sued, and we pushed, and they came back and told us there were other emails to search, but they never told the court there were the Clinton emails that they had just uncovered. They never told us. In fact, they wanted us to shut the case down before telling us about the Clinton emails. That's the bad faith we want investigated. And we want to ask Hillary Clinton some questions about this, Cheryl Mills some questions about this, and get some more information from the government about how they handled these and other FOIA requests. Well, Judge Lamberth, so I went to the hearing this morning with Ramona Kurtka, who you may have heard from me, and I know she's appeared on some Judicial Watch videos as well. And I know Lauren has been on Judicial Watch videos, who handled our case yesterday. So again, I go into court with Ramona. Ramona's handling the case from us. And Judge Lamberth comes out and says the following, and I'm quoting by memory, but it's pretty close. He was upset to read the IG report, a famous IG report by the Justice Department on the Clinton email matter, to see that in the IG report that Cheryl Mills, Clinton's, as I said, counsel, Deputy, I think Chief of Staff, was granted immunity by the Justice Department, especially since Judge Lamberth, he said, this is Judge Lamberth saying this, especially since he had found her to have committed perjury in another Judicial Watch case. He was also upset by the false statements to him by the State Department and the Justice Department. Now, what was that other case that Judge Lamberth was referencing? This was Judicial Watch's case in the FBI Filegate matter. This is what bugs me about this Clinton email matter. I keep on calling it matter, forgive me. I don't believe it's a matter. I think it was a criminal enterprise. But it's a shorthand way of calling it. Back during this FBI files case we had been pursuing, we found out in the White House, the Clinton White House had a bunch of emails that they knew wasn't being records managed, meaning put in a pot that would be searched in response to Judicial Watch's request for documents in the litigation and congressional subpoenas and then a special counsel investigation. There was a whistleblower who came forward and told us that from the White House. So essentially there were all these emails that weren't being searched and they didn't want to tell anybody that we weren't looking at those particular emails. Who was involved in covering that up? Cheryl Mills. And Judge Lamberth specifically found her behavior to be loathsome and entirely inadequate because she didn't tell anyone about this despite her knowing that these emails had not been searched. And outrageously, there was never an obstruction of justice brought against anybody in the Clinton White House for covering this up. Judge Lamberth, I don't recall he even did much about it, even though he was outraged about what specifically Cheryl Mills did. So this wasn't the first time emails had been hidden from us. So, but of course, Judge Lamberth remembered that. And he was upset about what the Justice Department and the State Department had done in lying to the courts and frankly the American people about the Clinton email issue. So that was what the hearing was about. And this is what was outrageous about the hearing. We had a Justice Department attorney. The State Department has taken the position still, 2 years after President Trump has been elected, that Hillary Clinton and the State Department should have to answer no more questions on the corruption involved in the Clinton email scandal, about how it obstructed our FOIAs, how the courts were misled, how documents went missing and were destroyed, as I said, the 28,000 that are now permanently missing unless the FBI is told to do something else or the courts intervene and get the State Department to do something else. And we had a Justice Department lawyer in an effort to stop Judicial Watch's request for discovery, prevent more questions from being answered, cite the FBI sham investigation as reason not to do anything because the FBI looked into it, and quoting James Comey as a reason not to do anything. Who is running the Justice Department? Who is running the State Department that this is their position? By the way, we asked them, have you changed your position? They haven't, meaning from the days of Obama and the early days of the Trump administration before anyone was really appointed. They haven't changed their position. And Judge Lamberth was very upset with the Justice Department for lying to him, and they're trying to explain that they didn't lie to him when in fact they did mislead him. So I don't know what Judge Lamberth is going to do. I suspect we're going to get some discovery, but I don't know. But it was quite the hearing to see the judge tear into the Justice Department that is still defending Hillary Clinton. We are in court next week. As I said, Hillary Clinton took these records illegally, destroyed some of them. The law requires that when that happens, an agency write a letter and get the Justice Department to do something about it. This State Department objects to having to do that. And we're going to be in court before an appellate court next week trying to get a district court that had already been overruled once, the lower court, in not forcing the State Department to do something, to get the lower court to get the State Department to do what the law requires here. The State Department doesn't want to tell the Justice Department to go out and get the rest of Hillary Clinton's records, even though there's all this information that not enough was done to get them.